Alright, hey guys, thanks so much for watching this video, checking this out. This is the MBE Torts Video Series. MBE, of course, standing for the Multistate Bar Exam. It appears on just about every single bar exam in the country. It's clearly the most important thing you're going to need to study for. And if you don't know what that is, or you're not a law school student, or you're not taking the bar exam, I can promise you there are much better videos on YouTube that are far more entertaining. But if you are in the unfortunate position of having to study for this thing, you are more than welcome to join me for the rest of this video and the other videos in the series. So let's get started. The MBE has 6 different subjects, torts being one of them, obviously. And what I've done here in this series and in the other ones is sort of mapped out exactly what's going to be on the exam. The National Conference of Bar Examiners, the NCBE, those are the guys who make this test, and they release an official outline of all the possible subjects and topics that could be on the MBE. By outline, unfortunately, they don't actually have any content. It just has the list of the topics and all the different subtopics. But I've gone through and put some meat on the bone, so to speak, for all of that to create an in-depth outline that actually maps to the official outline of what will be on there. So the goal here is to make sure we study every single thing that could possibly be on the exam, and that we don't waste time studying things that won't be on the exam. That being said, let's get started right off the bat here with intentional torts. If you do look at the official outline, I do have them on the website, and you can see them on the NCBE's website. The first part of torts is intentional torts, and Section A is harms to the person. So we're going to look at all the different intentional torts. But before we look at the torts themselves, we're going to look at 2 different topics. The first one being the intent requirement. This is what distinguishes an intentional tort versus a negligence-based tort. The majority of your time studying torts in a torts class is you're talking about things like causation, negligence, reasonableness. Some classes, mine didn't. They don't discuss intentional torts because they're pretty basic. They're pretty easy. You have some elements, and if those are satisfied, you have an intentional tort. So here, the biggest thing is that every single one of them, with a minor exception, which we'll discuss later, has an intent requirement, an intent to cause harm, and there must be evidence to demonstrate this intent. An example being that someone wants to punch someone else. They decide, the defendant says, "I don't like you, plaintiff. I'm going to slug you," and he throws a punch at that guy. That's an intentional act to cause some sort of harm. The negligence version of that would be if a defendant was blindfolded, just swinging his arms in a public space and smacks the plaintiff. That's unreasonable behavior, negligent behavior. He's still liable, but not for an intentional tort. He'd be liable for negligence in that situation. Here, there has to be an actual intent to cause some sort of harm. For your purposes on the bar exam, they're going to throw at you potentially a question where the intent is a bit ambiguous. So, for instance, an interesting example here is the distinguishing between an intent to engage in the conduct itself from an intent to cause harm. So an example, simple example, is that someone may intend to drive at a high rate of speed. So there is an intent of some sort. They want to go fast. They want to drive really fast on the road. But this doesn't mean that the person had some sort of intent to crash into another driver. And that's what, in some instances, is hard to prove. The victim might say, "Oh, we just got divorced. My husband hated me. He wanted to run me over." And they want to claim it was an intentional tort, and the guy might say, "Oh, I was just speeding. I didn't want to hit anybody. I was just simply negligent." There's really not that much of a difference because you're still going to be liable for damages. But an intentional tort, what's good about those, this is something you could potentially throw into an essay, is that an intentional tort is easier to establish in court. You don't have to start having the jury debate things like reasonableness, the reasonable person. It's cut and dry. If the person did the thing and had the intent, they're liable. You threw a punch, the punch landed, you're liable for battery. Enough said. The second issue that you have to be aware of on the bar exam when it comes to intentional torts is the concept of transferred intent. Now, what this means is that a defendant might have some sort of original intent to do something bad, but their conduct results in a different harm. The example I have here is the defendant shoots an arrow at his enemy, plaintiff 1, but that guy ducks, and the arrow whizzes past him and strikes a bystander, plaintiff 2. Now, defendant didn't intend to hurt the second guy. He only intended to hurt the first guy. So technically speaking, there is no intent, but it transfers. So if you intended to do something bad to somebody, you're liable for anything else bad that results. The guy ducks, it hits somebody you didn't even know was there, and you are guilty. Or I should say liable. And again, this is not worth reading. I should say now that I have a lot of words here. If you want clarifications, you can hit pause and read some of this stuff, but this is all on the website, and here, I'm going to just be sort of lecturing, so you can just listen as opposed to reading. There's a lot of words, obviously, on these slides. Too many, probably. But anyway, if the defendant does something bad and has an intent to do that, he's liable for anything else that happens. And, what I was going to say was this. The benefit here is that, again, it's easier to prove an intentional tort in court than starting to have to do things about reasonableness and negligence and the jury and all that. Because technically speaking, the defendant who shot the arrow, it's reckless because if your victim ducks, there might be someone else there, and that's not something the reasonable person would do. So theoretically, it is a negligence tort, but what it really is an intentional tort, and the intent transferred. Okay, so let's jump into the different intentional torts that you might see on the bar exam. These are pretty much, obviously there are others that exist, but I think that for your purposes and the limited memory capacity that we all have, these are really the ones that will likely be on the bar exam and that are worth taking the time to memorize. And this is, I'm not big on pure memorization because there's just so much material for a bar exam that it's better to understand a lot of stuff conceptually. But this is an area where memorization can help you because these torts have specific elements, and if they're met, then the defendant's liable. If not, the defendant is not liable. So it really is a memorization thing. And because a question might put some facts before you and ask you if a certain intentional tort applies, and you have to think of what the elements are. Or the hard questions are when they give you a set of facts and they say which of the following apply, and you've got to start thinking of all the different elements for many different of these torts. So it's kind of annoying, but let's get into each of them and let's see how we can think of them individually. Because I have this, if you notice here, the blue, I've kind of summarized what the tort means. I mean, these are the elements here that are numbered, but this is really how you can think of it. So battery, this is the first one. It protects sanctity of the body. So we all have bodies, and we're entitled to protect them. And if somebody violates our body, we can go to court and sue them for battery. So what is a battery? It is a harmful or offensive contact with plaintiff's person or anything held or connected to plaintiff. So this is a bar exam one of those things that could be on the bar exam alert that somebody might be holding something or it's attached to them. Their chair is a good example. I've been sitting in a chair doing work. I get up to get something off a shelf. Somebody pulls the chair from me. I sit down and fall. Well, the person didn't actually touch me, but they did contact something that was held or connected to me. And if I fall, if they pull a chair from me, that's absolutely harmful or offensive. So that's a battery. Because if you didn't know that, you might be like, well, they didn't actually touch the person. Maybe that's not a battery. No, it is. The rule of thumb here is if someone does something and hurts you intentionally, it's a battery. Harmful or offensive, this is also bar exam alert. It's anything that a reasonable person would describe as such, what someone of ordinary sensibilities would not want done to them. So if you're walking in the mall and it's crowded and someone bumps into you, that's just life. You can't sue someone for battery. But if someone in the mall just pushes you out of the way, that way they can get online someplace, that is a battery. And, one thing also to think about is that batteries really kind of happen all the time. It's only the rare instance that somebody actually goes to court and sues over it. So you really need to think of yourself like somebody who's just sue happy crazy, because things like that, you're at the mall and someone just pushes you hard. Now, no one sues for that, but that technically is a battery, and if that's on the bar exam, you have to say that it's a battery. Or like if your doctor touches you during surgery and in your arm, does surgery on your arm but didn't have permission to do surgery on your arm, that's technically a battery because he touched you in a, and you didn't want that. And obviously they would assume that there was something harmful or offensive about it. I would have to imagine that cutting your arm open during surgery is harmful or offensive unless there was some sort of emergency. So look to battery anytime you see some sort of injury to a person or damage or anything that's unwanted. And it can be a slight touch. It doesn't have to be something huge. And also there can be a gap in time from when the defendant sets in force whatever motion that he's using to commit the battery, because again, it also doesn't have to be the defendant physically doing the touching. If you throw something at somebody and it hits them, that's a projectile that they've thrown. So there can be a gap in time. If you set a bomb and you time it and the defendant leaves and it blows up and the shrapnel hits the plaintiff, that is a battery. Assault protects tranquility or peace of mind. Now, this is one that before I went to law school, I thought assault was a battery. I had it backwards, or I didn't even consider what a battery was. I just thought of assault because that's what you see in the TV shows. They always talk about assault. I guess battery is just not that, I don't know, it's not that, the word doesn't have the same cachet. But anyway, assault is sort of like protecting you from the fear of getting a battery. It's your peace of mind that you can walk around without having to worry about somebody committing a battery to you. So specifically, an assault is when the defendant is in reasonable apprehension of an immediate battery. Someone pulls out a gun, puts it in, right up to your face. You're thinking, oh man, I'm going to get shot, or I might get shot, and this is not good. My peace of mind has been violated. So the apprehension, what we're talking about here, is actually the thought that a battery might happen. And the reason why we highlight that word is because the plaintiff has to have some sort of knowledge that there's going to be an immediate battery. So the example I said, a gun is in my face. If I was asleep and somebody came into my house, put a gun next to me, and was really honestly considering shooting me, I was in a situation where there might have been an immediate battery, but I personally was not in apprehension because I was asleep. My peace of mind was not violated because I didn't know the person was going to do that. So the plaintiff has to have some sort of knowledge that the battery is forthcoming. And in order to have that knowledge, there usually needs to be some sort of conduct or gesture on the part of the defendant, like pulling out a gun or making a fist and as though you're going to throw a punch, something that would signal that a battery is forthcoming. And of course, the battery need not actually occur. We're not talking about battery. We're only talking about a person being in fear that they might be the victim of a battery. And another bar exam alert here is that an assault will have occurred even if defendant later withdraws his threat. So if I'm at a bar and someone turns to me and says, "I'm going to slug you, pal," they make a fist and they put it right in my face, I'm thinking, oh my God, I'm going to get punched here in a bar fight. This is not good. And then the guy gets talked down and he apologizes to me. That's nice. Now I'm no longer in fear of an immediate battery, but I was at some point of time. And so an assault occurred regardless if the threat is withdrawn or there's apologies. The idea is I had peace of mind and it was violated by this guy. So you're entitled to tranquility or peace of mind at all times. If anybody messes with that, they might be liable for assault. Now, unlike battery, there cannot be a significant gap in time. Why? Because we're talking about apprehension of an immediate battery. It's obviously, well, let me give an example. I'm walking down the street. Someone says to me, "I don't like you. I'm going to come to your house in 2 weeks and punch you." Well, yes, my peace of mind is violated and my tranquility, but not to the same extent if I thought he was going to punch me in the moment. If there's a gap in time, you can do something about it. I could get a restraining order. I can go to the police. So even though your peace of mind and tranquility is violated, it's not to the same extent as if you think a battery is actually forthcoming. So the defendant can't say he'll be back later. There needs to be an immediate battery. Obviously not a second, 2 seconds, but you have to be thinking, I am about to be the victim of a battery. False imprisonment. This protects freedom of movement. Everybody is entitled to move freely. And if that's violated, the person responsible for that is liable to you for false imprisonment. What are the elements? Defendant restrains plaintiff in a bounded area with no reasonable means of escape. So if I am in a high school gymnasium and some gym teacher decides he wants to trap me, and I'm in there, he locks all the doors, he can't claim that, he wasn't actually trapped because if he had climbed up to the ceiling, he could have unlatched, some door in the roof to get out. But I mean, that's ridiculous. That's unreasonable. There has to be no reasonable means of escape. So even if there's technically a way out, unless an ordinary person could have used that means of escape, you're trapped. Normally, this tort requires an affirmative action, like the gym teacher to purposely lock the door or something. If I got myself locked in the gym and the gym teacher comes by and sees me, technically speaking, he doesn't have a duty to release me. He says, well, you're an idiot. That's your own fault. And he can continue on with his life. But that changes if the defendant owes a duty to the plaintiff. So what if I was a student at the school? I would have to imagine that there's some tort principle in most states that say that academic instructors have a duty of care towards their students to protect them, just like they say about a common carrier. So if someone owns a hotel, they also have a special duty to their guests, things like that. Or a caretaker, if I'm an official caretaker to somebody sick, you have a legal duty. So in that instance, if you're trapped and someone with a legal duty to you walks by, they do have to release you. So if I was a student at the school and the gym teacher has a duty to protect his students, he has to release me. So if he were to continue walking, his forbearance would operate as a restraint. Another thing here before we move on to the next one is most of the time, there's false imprisonment, there's physical boundaries, a cage, shackles, or something like that. But another example is what they call constructive restraint, when there's some sort of threat that would compel a reasonable person to remain trapped. Uh, Now, imagine that I'm accused of shoplifting. I'm at Kmart or Walmart, whatever, and the manager and the security guard brings me into the back of the room. You know, they're not police officers, and they don't necessarily have the right to just take anybody and, imprison them, so to speak. And I'm sitting in the office, and the security guard says, if you get up and walk out of here, I'm going to tackle you and pin you down. If the guy's twice my size, I would consider that a significant threat. So even though I wasn't locked anywhere or bounded or caged, I don't think they have cages in Kmart, that operates as constructive restraint, because reasonable people are not, they don't fight off security guards. That you're effectively imprisoned. But if they said, oh, if you get up and leave here, we're not going to give you the 10% discount next week during the sale. I mean, that's not really a significant threat. So the next intentional tort, which actually is the one tort, ironically, that isn't the intent requirement. We'll get to that in a second. It's ironic because, and this is a good way to remember it, actually, now that I think of it, the word intentional is in the title, yet this is the one tort that has an exception regarding intent. We'll get to that in a second. But intentional infliction of emotional distress. This protects tranquility or peace of mind, similar to assault, but in a different way. Assault protects you from the fear that you're going to be the victim of a battery. Intentional infliction of emotional distress protects you from being the victim of some sort of outrageous conduct that causes you distress. So the defendant has to do something outrageous, and the result of that outrageous conduct is a plaintiff who suffers from severe distress. Examples of outrageous behavior: anything that's beyond normal levels of decency. Stalker, someone doing something really, it's hard to think of these things sometimes, but it's sort of the sniff test here. If the defendant is acting in a way that is just simply beyond the bounds of normal decency, that might qualify. And this is sort of a catch-all thing, because you're saying the defendant did something that was just so bad that it made me upset. And, that's that. The plaintiff doesn't have to manifest a physical reaction. So the plaintiff doesn't have to say, oh, I got a panic attack, or I had hives on my face, or, whatever. But there has to be some sort of indication that the distress was severe. Even if they just say, I was so scared, it made me breathe heavy, I couldn't concentrate on my work, something like that. One thing here that this is a bar exam point or alert, is that the First Amendment can sometimes be a countervailing factor here. If the President of the United States can't say, the leader of the opposing party was very mean to me and it caused me distress, he was being outrageous in things he said, I want to sue him. You're the President of the United States, you're a public figure, the First Amendment protects criticism of you. That's obviously an extreme example, but just remember that this is speech we're talking about whenever we're talking about the government upholding a case that punishes speech. The First Amendment comes into play. So here's the intent exception when it comes to intentional infliction of emotional distress. Recklessness replaces intent. Unlike the other intentional torts, the defendant does not have to intend to bring about an emotional reaction. The reason for this, to try to think of this conceptually, is that you can't really intend to cause you can sort of intend to do it, but like, for instance, a battery, if I say I want to punch someone in the nose, you make a fist and you punch them in the nose. But if I said, I want to make somebody upset, you can try to make them upset, but you can't open up their skull, get into their brain, and make them upset. You can intend to do the conduct that you hope will make them upset. Now, the way the law handles that is by saying, was the defendant reckless in their conduct? Reckless meaning they did something that might have brought about an emotional distress. An example here that I'll discuss is that imagine someone, they're skiing down a mountain. They purposely go as fast as they can and screech to a halt directly in front of plaintiff. Now, even if the defendant did not intend to cause emotional suffering, he might be liable for intentional infliction of emotional distress. That was clearly reckless. The person might be very scared of that. Now, note that the defendant intended to stop short in front of the plaintiff, and it is that reckless conduct which caused the distress. Now, an astute person might point out here that that actually could be an assault as well, because the plaintiff was in reasonable apprehension of a battery. And that might be the case, but another argument you could say is that it all happened so fast that the plaintiff didn't even actually get a chance to appreciate that knowledge. So, that also highlights the fact here that sometimes an activity can qualify as multiple torts. But the idea that I'm trying to highlight here is that the person does not have to say, I want to make somebody upset, therefore I will ski fast and halt in front of them. The person has to only have the intent to do the halting, to do something. And they're being reckless with somebody's emotions because it might cause them distress. The next tort, trespass to land. This protects the possession of land, of real property. Now, there's a distinction between real property and personal property. Real property meaning land, fixtures on land, like a house. You have a right to exclude people and to use and dispose of that land as you please, and the government will protect that right. So, the elements of trespass to land is that there are a physical invasion by defendant himself, and this can be on foot or in vehicle, or by a projectile set in motion by a defendant. If somebody operates a drone that is hovering, right in your backyard, literally right over your backyard, and that is a trespass. You have a right to make sure people don't bring their things on your property. It's a trespass just as though if the defendant hopped a fence and went into your property. And the plaintiff has to be the person in possession of the land. Possession, of course, being different than ownership. This here is a bar exam alert because there could be a fact pattern where everything looks like trespass. The defendant hopped the gate, went over, whatnot. But the plaintiff, the person suing, is actually the landlord. The landlord is not the person in possession of the land. It's the tenant who is in possession. Or the owner might not rent the land, and he is the person in possession. The bottom line here is the person bringing suit, the plaintiff, has to be the person in possession. Your landlord can't decide who is trespassing or not. It's the plaintiff who says, that person is unwelcome. I'm the one who says they're unwelcome. They've nonetheless invaded the land that I'm in possession of. As such, I'm going to protect my possession by bringing them to court for trespass to land. Now, most obviously, this occurs on the land. Obviously, we call it trespass to land, but by land, we're really talking about the item that we're protecting, and the item of land is protected from things that might trespass underground or in the air as well. So, like I said, the drone is an example, or somebody that is creating a tunnel underground under your property. But only if it's in a reasonably close distance above or below. If a jetliner is a mile above your land, or even less than that, that's not a trespass. Now, the projectile, I spoke about that. If someone is shooting something into a rocket into your property, that is a trespass, but it has to be tangible. An intangible projectile does not qualify as a trespass. So a wafting smell from a factory, annoying sounds, those are nuisances as opposed to trespasses, and we get to that later. A trespass is actually some person or some actual thing that comes onto the land. You don't want it there. Or I should say that the plaintiff in possession doesn't want it there, and that is a trespass to land. The sister tort to this is trespass to chattels. Chattels being a clearly outdated word. I don't think I've ever heard that used except in this context, which means it's pretty much a useless word. But nonetheless, that's what we live with. It protects the possession of things, personal property, the opposite of real property. The defendant interferes or intermeddles with a possessory interest in a chattel belonging to plaintiff. So now, why do I say interferes or intermeddles? Because there is another tort we'll get to in a second called conversion, which is the actual taking. This is sort of like a lesser thing. Now, with trespass to land, you can't physically take land. I can't come home one day and there's just a giant pit where I used to live. Someone took my land. You either go on or you don't. But with personal things, there's sort of like a spectrum. What is the trespass? Is it a minor trespass or is it a major one? So here's the minor one: trespass to chattels. You're only interfering or intermeddling. Imagine that someone takes your car just for a joyride around the block, or they hide something that you own, or they damage something that you own. That's a trespass to chattels. And again, the plaintiff must be the possessor of the chattel. An example of a plaintiff is leasing a car. The car dealership can't be the one that's bringing this. It's the person who is dispossessed. The damages here is the cost of rental or the cost of repair to the chattel. If someone takes my car for a day and then leaves it back, I haven't been dispossessed of it, but they did violate my right to possess it. So I can go after them for the cost of renting it. Or repairing any damage, repairing any damages to the property. So again, like if it's a car, they take it for a joyride, I can say, well, let's figure out what it would have cost to rent that and what the repair costs are. And you might be saying, well, that can't be right. You get off pretty easy. A joyride, you just have to pay for the cost of renting it. If that were the case, why go to Hertz when you can just hotwire your neighbor's car and take it for a day or two? That's true. I guess, you are just paying for the rental cost, but you are also would be guilty probably of grand theft auto. That's fun in video games, but I don't think that you want to go to prison just to avoid having to go to Hertz. So a rule of thumb here is that they dispossess the chattel, they impair the condition quality, deprive for a time, I should say. These are the rules of thumb. There is no real good explanation. It's anything that except an actual final taking. And when it comes to a final taking of something, that's when we get to conversion. Why do they call it conversion and then not stealing or robbery? I don't know. I guess because you're converting the possessory interest from one person to the other. Conversion. There you go. I don't know. This protects ownership of things, again, personal property. Defendant appropriates a possessory interest in chattel belonging to plaintiff. It is nearly identical to trespass to chattels, but it is the more substantial version. We said that a joyride is a trespass to chattels, or another example of trespass to chattels would be if you put a boot on someone's wheel and they can't use their car until they take the thing off. But if you actually take the car for good, you hotwire your neighbor's car and you say, well, I don't want to give it back. I'm going to take it for good. That's conversion. You appropriated the possessory interest instead of merely interfering with it. The damages here are a forced sale of the chattel or return of the item to plaintiff. If I take my neighbor's Corvette, I hotwire it, and I drive it away, my neighbor brings me to court for conversion. There's one of two things. I either have to pay him the price for that car, or the court forces me to give the car back. Again, that's not a smart way to get your car by stealing it from your neighbor, because you're going to be liable in criminal law. But here we're only talking about tort. Theoretically, it is what it is. It's a forced sale. Now, obviously, that the example of stealing a car is pretty cut and dry, but things get a little more complicated if you're talking about corporations and there's a dispute over certain widgets that they're selling, and Corporation A keeps a hold of the widgets despite some dispute in ownership. A court might say, oh, there was conversion. You weren't entitled to those, so either give them the price of the widgets or return them back. No one's probably going to jail in that instance, but it is technically conversion. So we've finished Part 1, Section A, harms to the person, and next we will turn to intentional torts and the defenses to the claims for physical harm. So the defenses for everything that we just discussed here.